Welcome back to Court TV Live. I'm Michael Ayala. The U.S. Supreme Court will take up a pair of lawsuits that could end affirmative action. In other words, the use of race as a factor in college admissions. Now, the lawsuits claim that Harvard University and the University of North Carolina discriminate against Asian American applicants. The case will probably be argued in the fall and was filed by Students for Fair Admissions. Now, that is a Virginia-based group that has worked for years to rid college admissions of racial considerations. The Supreme Court has weighed in on college admissions several times over more than 4 decades, most recently finding race could be used to tip the scales in favor of a minority student in the case of equally qualified applicants, much as legacy or musical or athletic talent is used in that purpose. Now, the current dispute harkens back to the first big affirmative action case in 1978, when Justice Lewis Powell laid out the rationale for taking account of race, even though court barred the use of racial quotas in admissions. All right, still with me, constitutional lawyer Andrew Lieb and criminal defense attorney and former prosecutor Gregory Walker. I'm bringing you back in as well on this discussion. But Andrew, I'm going to start with you. The culture wars continue with this court. You know, that's what folks have called it. They've attacked religious rights. They've gone on to discuss abortion. They take these cases because they have something they want to do or say. This is a conservative court. They've taken these cases. Want to get your thoughts on whether affirmative action has any future in this country.
Well, I first want to clarify this affirmative action conversation, because I think we're missing what Justice Powell said in the Bakke case, which you referenced from 1978, which is the key to this whole conversation. Justice Powell expressly said that you cannot use race to remedy societal discrimination. And that's what you and I and common people think about when we're talking about affirmative action. What instead he said is the compelling governmental interest, the compelling interest in this case was that diverse student body creates a robust exchange of ideas like you and I are having right now. So the interest is that. Now, to your specific question, in 2016, Fisher was a 4-3 liberal conservative decision. We lost one of the liberal justices and gained 3 conservative justices. So simply on math and the fact that the Powell was analyzing the Harvard basis for admissions, which is now before the court again, signals that they plan on reversing this.
So now you've mentioned how the court looks at this. So how does this court get to overturn that decision and say that race cannot be used at all? Because obviously that 4-3 majority found some way to justify with the Constitution and whatever's in there, the right to use that as a way of finding a diverse student body, which was a compelling interest for the state or for the federal government. So how do they go about reversing that, if that's what they're going to do?
They actually gave the roadmap in Bakke. In Bakke, Justice Powell said, one of the constraints, it wasn't just that you can't have a quota. You can't have a quota. It has to be race plus, as you were indicating, kind of like location or finances or religion or another thing like sex or legacy. But he also said it had to be limited in time. And in the case, he predicted in 25 years from 1978, hopefully we won't need this anymore. I will point out that Grutter, which was 25 years later, reaffirmed it. And then again, Fisher, some years later, reaffirmed it. But the main avenue for them to get around this is to say it's been long enough, and now the compelling government interest from the federal government, the state government, as you indicated under Title VI funding, is no longer necessary because, you know what, we have enough of a diverse student body. I don't know if that's true, but that's a compelling argument.
Yeah, no question about it. Now, Greg,